Welcome to everybody. I'm delighted to welcome you this morning to this introduction to French employment law. So I'm Catherine Leerwang, the General Manager of the Franco-British Chamber of Commerce. And before starting, I would like starting and handing over to Alexandra and Merci. I suggest that you all introduce yourself in order that we know who you are and what is your activity and maybe why you are here this morning. So I'm going to start with those who are abroad. Fiona, would you like to start?
Yes, with pleasure. Thank you, Catherine. My name is Fiona Mougenot. I'm an expert in French immigration, and I have a consulting practice called COME, helping both companies and private clients to arrive in France and to be able to work here. So I'm very interested, of course, in what the discussion will be this morning and learning more about how to handle the first hiring.
Thierry, would you like to introduce yourself?
Yes, in 2 minutes, because I have an emergency. I can introduce myself in a couple of minutes, if you don't mind. I'm sorry, I have a call. Sorry.
You're welcome. Amélie Kergoat? You're on mute.
Sorry for that. Hello, everyone. I'm Amélie Kergoat. I'm working for H React, and we are helping companies who want to expand their business in France, and we are working on HR topics.
Thank you, Amélie. Michel Cancet? Michel, would you like to introduce yourself? We can't hear you.
Sorry, I was looking for the unmute button. I'm Michelle Cansey. I work with AXA International. We're an insurance agency that in France that provide insurance for our Anglophone or English-speaking clients, and I work with Paulette.
Thank you. Then Martha Silitonga, would you like to introduce you?
Hi, everyone. I'm Martha. I'm a senior talent acquisition consultant from Polyglot. So yeah, it's very relevant to my day-to-day work about the French employment law.
Thank you. And I think there is someone else from Polyglot, Timothy Jack.
No. Timothy works with me in
Timothy, Amélie.
Sorry,
Timothy. I think Timothy is the same company than Amélie.
Yeah, that's well, I'm sorry for that, because he says that yes, working with Amélie, he has got problem with his microphone, so we won't ask him. And Paulette, would you like to say a few things about yourself?
Yes, hi, I'm Paulette Booth. I'm the manager of Agence AXA International. We're a specialist AXA agency helping English-speaking companies that are moving to France that need insurance. And we're really interested just to get a little bit more information on employment law, just so we understand the needs of our clients and can then help them with what they need to.
Thank you, Paulette. So AXA International, they are located in Toulouse. So we're delighted to have you here. Maybe we can start with you now, Anne-Hélène.
Fine. So good morning, everybody. I'm Anne-Hélène Squarneck. I'm a HR advisor, and I'm helping international companies to settle in France from their HR point of view. And obviously, I'm very interested by this coffee room morning. Thank you.
Yeah, I'm Agnès Liné. I work with Majid there, and I work for the Paris region, just next door. and I'm here to help our company to recruit in Île-de-France, Paris Région.
Thank you.
And I'm Nastasia. I work for Polyglot Group as well. And I'm an HR consultant, and I also work with international businesses that want to settle in France. So this is a good refresher and hopefully some new insights for me too.
Great.
Good morning, I'm Simon. I work for Polyglot. So as Nas said, we help international companies to develop their businesses and markets in France and Europe, and we provide HR services, obviously, but also recruitment, payroll, and translations.
Thank you.
So I'm Majid Orbit, so I'm a colleague at the Choose Paris region, which is the Paris region government agency dedicated to the attractiveness of the Paris region. So we support the foreign investors to set up their business by connecting them with the main actors that might need to set up their business in Paris region, such as a law firm, real estate agencies, co-working spaces, HR agencies, etc. And the bank, business bank as well.
Thank you. Valentine.
My name is Valentine Delavo. I'm working at the Franco-British Chamber, and I organize this event with Myrti and Alexandra.
Thank you for that. Thank you, Valentine, for your work.
Hi, I'm Marie-Gabrielle Chicli. I'm a chartered accountant, and for now I've got much clients abroad, but I've got one who contact me, a British company, want to set up a shop in France, and I know they will need to employ engineers here for hotline services, and so it was a good event for me to
understand the
follow,
needs.
yeah, to understand.
Welcome. So now I'm going to hand over to Myrti and Alexandra. So, and then you will start your presentation. So,
Myrti Lapuelle. So I'm an employment lawyer for almost 20 years now, working for a French company, obviously, but also US and UK company. We joined now the chamber 1 year ago. Yeah. So it's, I think, the second session of introduction to French employment law. Next time, I think that we will do something with Fiona. And I'm working with Alexandra for some years now.
Yeah, so Alexandra Bryant, I'm working with Myrti for a few years, as she just said. I have almost 10 years of practice as a lawyer, and I've been working in a few international law firms, and now we are working at Koblenz Avocat together. So I think we can start, Myrti.
Absolutely.
And go ahead. So Catherine said that we will explain all French employment law, which is very challenging. So no, basically we will, in 1 hour, we will just, draw your attention on what you or your clients may have in mind, some tips, and we will do that as much as we can through a case study. So Alexandra will explain what is the case. Yeah, if the screen wants to change. No.
On the screen?
Yeah. Great. Now it's working. So let's go on with a little case study. So idea was to present a kind of scenario of what could occur to you when recruiting in France. Okay, so let's imagine you are a UK company, so Blue Bicycle, that would like to develop in France and has decided to recruit its first salesperson. This person is not French, it's a German national, but he lives in Paris, and he will work from his home in France, even though from time to time he might be asked to travel and to go to the headquarters in London. So Blue Bicycle would like to find more about French employment law to know exactly, how to handle this first employment relationship in France. Okay, so we'll try through this little story to go through the key aspects, that you need to consider. And the first point is really the preliminary questions you need to answer yourself, and Myrti will develop that section.
So usually the first question that a small company, foreign company will ask is, do we need to set up a legal entity? And then the answer is no. There is no need to set up a subsidiary or a company in France. There is a specific URSSAF center where you have the possibility to appoint a representative in France. And basically what we would say to our client is, you need an accountant. So you will need someone to deal with the pay slips and, you know, health coverage. And basically that's it. What we would also draw the attention of the client is the risk around tax. Because depending on how they would structure the business, and here in this case the salesperson, and the power of this person, there's a risk of permanent establishment, which is a tax notion, meaning that they will pay some revenue in France. Usually the way it will be structured to avoid this is the salesperson will in fact only do business development, but it will not have the power to sign the contract. So that's the two, I would say, the two first thing that the client would have in mind. Then it will ask you what type of contract, either whether usually we have often a foreign client that would ask for independent contractor. Obviously the client wants something that is very flexible. For a case like here, like bicycle, when they start the business, they want to be able to get rid of the employee very easily. So they would often ask for, they would have in mind either independent contract or fixed term contract. So again, we will explain. So first thing is we will normally do not recommend fixed term contract. We will explain that it's not a flexible tools, because the reason why we could, first you need a specific recourse that is basically increasing the activity or replacement. There is many others, but mainly and you will have to explain to the client that opening a business is not a temporary increase of the activity. And then you will explain that fixed term contract, even if it seems to be very flexible, it is not, because you will decide for a specific duration and you will have a very short trial period. If you're not happy with the employee, or if it's not working, you will have to pay until the end of the fixed term contract. Interim contract is pretty the same. And then you will have to choose between permanent contract or independent contractor. So again, we will explain that if there is a link of subordination, if the employee is integrated in the business, independent contractor relationship is not the good option, because you will have a risk of, at the end of the contract, requalification, a claim for requalification of the contract. And in addition to that, you would also have a risk that the URSSAF would claim for the payment of the social contribution. So independent contractor is really when you need a specific knowledge, and you have somebody that is doing something for other clients, basically. And then you have the last one, which is one that we heard more and more, which is umbrella contract, which is maybe in France more known about portage, which is something that we have more and more. When I start my career, it was strictly forbidden. So the rule change about that. Again, portage can only be used in very, very specific situation. The idea is that you have a company that will deal with the administrative part of it, but the employee is supposed to find itself his own business. So It's in fact the employee of the umbrella company that would say, look, I have a new client and I would have a mission, but it's not like an interim contract where the interim company would provide the mission, and you also have it should not be permanent. You also have a duration. We also very quickly remind you about the independent contract, that there's also a duty of care. So if the relationship is structured with an independent contract, you will have to remind your client that they have the obligation to check that they are registered and that they pay their contribution, and the need to check on the site of the URSSAF that they are properly registered. So now you contract. The usual question of the UK and US client would be background check. The culture is not at all the same that in the other country. Background check in France are first very regulated, and for example, case where you can ask for a criminal record copy is very limited, mainly for a job where, for example, you will be in contact with children, or if you have to deal with money. But in other case, you cannot ask for a copy of the criminal record. You should also know that in practice, when you will call a previous employer, and for example, there is a litigation going, they will rather prefer to explain that it's a great employee, because if the employee has a new job, the damages in front of the labor courts will be less. So the background check culture is not really a French culture. Work permits, so we are not doing immigration. If we have any queries, we will deal with Fiona. It is very, very specific, and you really need it is really an independent practice. Would just remind that the UK is no longer in the EU, and that you need to have a work permit when you are a UK resident. Pre-hiring declaration is more, I would say, an administrative point, but you should also have in mind that you have an obligation of declaration. And then now you have cover basically all the immigration. So now you will start the drafting of the employment contract, and I would let Alexandra explain you what you have to have in mind.
So first, what is important for you to understand is that employment contract is not standalone. Okay, so there is a legal structure beyond, the employment contract that you need to consider when drafting the employment contract. So first, in France, at the top level, let's say we have the French Constitution. It's written, not very useful for you on a day-to-day basis. It's, for example, tell that employees have the right to strike in France. Then obviously we have all the treaties. So for example, some EU treaties might have some impacts on the day-to-day management, the employment law relationship. For example, just now we have a new directive which has increased the number of information you must provide to the employee when recruiting the employee. So it has a direct, sometimes, impact on the employment law relationship. Obviously, we have all the laws. So in France, we have a parliament, as in all countries, that adopt the law, and then the government can adopt some additional statutory provision to allow us to implement the law. We call that décret ou arrêté. Okay, so usually we need to wait for those documents before we can implement a law, because it provides us with some practical aspect on how to implement the law. Then, and I will later on focus on that, what is important for you is to identify the collective bargaining agreement which you will apply to your business in France, because this is really key when drafting your employment contract and determining also what are the benefits you should provide to the employee. Then, of course, in your company, you might have some company practice, internal rules and regulation, policy. So, of course, this needs to be considered. And sometimes you are, an international business, you come in France, you have all your international policies, but they need to be adapted to France, okay? They can't always be adapted like that. And sometimes, for example, you might need to change them to comply with GDPR and so on. So it's not only I can apply my policy straight away to this new French employee. And then, of course, the key thing, and we'll focus on that, it's the employment contract. If the person is French, the contract will need to be in French, okay? So it can be bilingual, but the French version would prevail. So about the collective bargaining agreement, we have various levels of collective bargaining agreements. We have what we call interprofessional CBA, so which will apply to various business. You have industry-wide CBA, which is a CBA limited to a specific branch of business, of activity, okay? And then, of course, you can also have company-wide agreements, so basically collective bargaining agreement that are negotiated at the level of the company. And in France, there has been a lot of change in the law. So now it's more easy to negotiate a company-wide agreement, even if you have only a few employees, even if you don't have any staff representative or trade unions. So this has changed and has given a bit more flexibility, for example, on working time. So in our case, if I go back to our Blue Bicycle company, probably the collective bargaining agreement that will apply is the collective bargaining agreement called automotive services, because it covers the cycling business, okay? And in this collective bargaining agreement, the employer will find a set of rules to follow, such as on probation period, notice period, the severance indemnity in case of dismissal, but also information on the level of healthcare and welfare coverage you need to provide to the employee, because in France, employees are not only entitled to the basic social security coverage, but also to what we call in French mutuelle and prévoyance, which increase the level of coverage. So it's why it's really important to find the CBA, and it's really rare for business not to be covered by CBA. So if you think you are not covered, you might check that with a lawyer or your service provider to be really sure, because otherwise, employees might claim compensation for any loss, suffered. And this can have important impact. For example, if you forget to do the prévoyance and there's a really serious accident, it can be a lot of money because you didn't provide them with the correct level of benefits. A few really specific points of attention when drafting the employment contract. First point is about the probation period. So the probation period is regulated by the law and by the collective bargaining agreement. So the basic rule is that for an ordinary employee, it will be 2 months, 3 months for a supervisor, and 4 months for a manager, an executive. It can be renewed once, but only if the collective bargaining agreement provides for it. This is the general rules of the law, but again, you need to check the CBA because sometimes the CBA provides something differently. Okay, so it's really important to check that. If you want to end the probation period, it's quite easy because you don't need to give a justification to the employee, or the employee also doesn't need to give you an explanation. There's only a short notice period, which will depend on how long the probation period has been going. A useful clause also in the contract is what we would call the mobility clause. So for example, in the case of a new salesperson that you want to hire in Paris, I don't know, perhaps in a few months your business will have expanded, or you found out that it's, not the best option to be in Paris, but you might to go elsewhere. And so it might be really useful to have a mobility clause so that, for example, you can say the person could be asked to work elsewhere in France, or not only in Paris, but Paris region and so on. So it's something quite useful to have in the contract. Obviously, in the contract, you will have a clause on base remuneration. Here also, you need to check the law and the collective bargaining agreement, because in France, we have a minimum legal salary that we call the SMIC, but also the collective bargaining agreement will give you a minimum salary depending on the level of the job of this employee. So you need to comply with that minimum salary. Also, sometimes we have some clause in the employment contract about variable remuneration, because obviously employees like to have this written. So you just need to be really careful in the way you draft the clause, because usually we would recommend to put something like you know, you have a variable remuneration, potentially, I don't know, 20% of your base remuneration, but the rules will be defined at the beginning of every year by the company, because otherwise, if you set up the rules, the targets, everything in the contract, if you want to change, you need the agreement of the employee. So you must be careful not to put too much in the employment contract. Another clause which is important, and Myrti will talk about that later, is obviously working time, because we have various options in relation to working time. And here also, the collective bargaining agreement is key. Also, sometimes, if it's not sufficiently flexible, I mean, the industry-wide collective bargaining agreement, here you might find it really useful to negotiate your own company-wide agreement to have something more flexible for your business. Another clause we find regularly in the employment contract is a non-compete clause. So we would not recommend to put non-compete clause in any type of employment contract. Sometimes, you know, people just think, oh, I always need a non-compete clause. The thing is that really this non-compete prevents the employee from finding a new job. So it should be only used when it's really justified to protect the business. And also we have strict rules in France, so it must be limited in time. So you need to check the collective bargaining agreement, but let's say it's really rare to have more than 1 year. The geographic scope must be limited. So usually it's a region or France. It's really rare to have it beyond, you know, like European Union, worldwide and so on, unless for really top job, you know, a CFO of a really big business and so on. And also it must be financially compensated. So here also you need to check the collective bargaining agreement. Of course, it depends on how long lasts the clause, but usually it's at least 30% of the salary of the employee. So it costs some money for you to have this non-compete clause. What you can do if this is also not prevented by the collective bargaining agreement is to add a waiver clause in your contract, saying that at the end of the employment contract, the employer can decide to renounce to the clause, and then he will not have to pay the financial compensation. But also what we see is that our clients just forget. They put 10 years ago a nice little non-compete clause in the contract. The employee resigned, and they realized 3 weeks later, but it's too late because in the contract it was written 2 weeks, that they forgot to waive the clause, and now they need to pay the non-compete indemnity, even though the guy is not going at all at a competing business. So it's really important not to put it in all contract and to check when you have you dismiss someone in case of resignation and in any form of termination, whether or not you have this clause in your contract. Really quickly, because of course Myrti started to talk about that, you need really to understand that fixed term contract is strictly, you know, regulated in France. So first, as said Myrti, it's only for a precise and temporary task, and you need a specific ground, such as temporary increase of the activity, replacement of an employee, or you already recruited someone under a permanent contract and you're waiting for this guy to arrive, then you can do a fixed term contract. So in our little case study, I mean, sailing bicycle is the core of the business of our bicycle company. So you can't say, oh, I'm not really sure about the market, let's do a fixed term contract, because you are not in one of the authorized ground. And you will see later, I mean, it isn't that complex to end a permanent contract. And I mean, if the length of service is not really important, it will not cost you, you know, that much money, okay? Whereas if you don't comply with fixed term contract, of course, there is reclassification risk, and also there are criminal sanctions behind non-compliance with fixed term contract rules. You need to provide a written contract in the 2 days at the latest after the start of employment. You have mandatory clause, such as indicating, for example, the name of the mutuelle and the prévoyance, so the healthcare and welfare coverage I talked about. There's also a principle of equal treatment with permanent employees. Myrti will talk about remote work, but usually we have clients who say on a fixed term contract, I don't want them to offer them remote work. And then we explain to them, no, because there's this principle of equal treatment. It's not because they're on a fixed term contract that you can do that. You could say, I want for everybody, I don't know, 6 months of length of service, which is a way of preventing fixed term contract. Perhaps you have remote work, but it means an equal rule for everybody. Then you have a really strict rule on the duration of the contract. Usually it's not more than 18 months. In some situation, it can be an open term contract. So for example, you are recruited to replace this woman who is on maternity leave until she returns. So then you don't need to put a written end date in the contract. And there are also rules that prevent you from recruiting again and again on the same job an employee on a fixed term contract, because in certain situations you need to wait a waiting period, which can be quite long, sometimes 1/3 of the duration of your fixed term contract. So again, it's not really that flexible. And at the end of the contract, you need to pay an indemnity to the employee of 10% of the salary he received, unless, for example, you ended the contract for gross misconduct, or he left because he or she found a permanent job. And as said Mirti, ending the fixed term contract is not that easy, because you can't really dismiss the employee, or if you have economic difficulties, you can't end the contract. So there are limited options. So mutual consent, gross misconduct, the employee has been recruited under a permanent contract, and there's a last one, which is quite rare, is when the employee has been declared unfit to work by the occupational doctor. So then you can end the fixed term contract. So you see, fixed term contract is not always, I mean, at least for a case study, the ideal option. So now we'll let Mirti give you a few insights about working time.
Which is the, I would say that the foreign clients, when they start a business, so almost from the beginning, they will ask for 2 questions. People in France does not work. So I will handle that, and termination, but we will see termination after that. But they will basically focus on these 2 points for a very simple reason, is that it could be very expensive. So working time in France, basically the usual working time are in hours, as you know, 35 hours a week. Overtime, so any hours that would be worked beyond 35 hours would have to be paid, or I would say compensated, depending, it could be money or rest, with an increased rate, which would be 25% or 50%, depending if it's the first 8 hours or the next 8 hours. And you will have an overtime selling, which is usually 220 hours per year, but you will also have to check the CBA, because CBA could provide for specific selling for the overtime. So first option would be 35 hours. Generally, the company will say is not enough. And then you will have to find other option. The other one that is very used in France, even if now I have some clients that don't want to use it anymore, which is forfait jour, so working time in days. So this one is normally very flexible, because you will not count any hours, you will only count days. The principle is that only for autonomous employee. So if you have an employee that is working for 9 to 10, and then 9 to no. 9 to noon, and then 2 to 5 is not working. For sales, normally it could work, because it will not be office hours. But here you would, as it's very flexible, it's also coming with some guarantee for the health and safety of the employee. So you have legal framework. So you need a CBA, either at the level of the industry, which is often the case, and a specific clause in the employment contract. As Alexandra mentioned, you could also have an agreement at the company level that you can negotiate even if you have 1 employee. And the advantage of that is that you could provide for a specific provision. I have one example in mind. We have a lot of clients. It's not the case of bicycle, and there's a Syntex CBA. The Syntex CBA is providing for very strict provision. So in an company agreement, you would be able to design an agreement that would fit to what you need in the contract. Why I was saying that I have some clients that is now not longer wanted to use the working time in days is that you also need to implement a lot of measure that is linked to the personal balance life. So you will have to organize in principle at least one meeting to check whether the professional time and the personal time are balanced. Keep in mind that the labor could provide for regular checking of that. Keep also in mind that we have a decision at the European level saying that we need to monitor working time, whatever the scheme is. Which is for forfait jour also the case. So it's not because you don't have hours that you don't have an obligation to monitor the working time. The issue here is most of the time either the employment contract or the measures that should be implemented to protect the health of the employee are not implemented, in particular the interview. So at the end of the contract, the employee will say, my clause de forfait jour is not valid, and they will ask for overtime. And they would provide you with a lot of emails in the evening or during the weekend, or and they will ask for overtime for the last 3 years. That could be very expensive. The last working time option, which is very specific, is exempt. Which are for senior executive, so really the manager of the company was very so often with for COMEX people, highest remuneration, high responsibility. So obviously here in the case of our sales manager, it will not be exempt. There is one option that is in the middle between working time in days and working time in hours, which is a forfait d'heure. So you will provide for a certain salary, and in this salary you will already in advance include the payment of the overtime. So for example, the contract will provide for 39 hours, and the remuneration would in advance pay or compensate the hours between 35 and 39. So very quickly, because here it's really, I would say rules that you should have in mind. So you also have to comply with maximum working time per day or per week. So per day it's 10 hours and per week it's 8 hours. Basically, you also need to comply with the minimum rest, which is 1 hour. You also have an obligation to provide a break to your employee, which is 10 minutes every 6 hours. And you also need to have a rest at the end, normally at the end of the week, which is 11 plus 24, which is 35 hours, including Saturday.
Yeah, and it should be on Sunday, the rest. We put Saturday, I don't know, we wanted probably to have a really long weekend. Just see that. So no, normally the rest is on Sunday in France, not Saturday. We'll change that.
You're right. So and for forfait jour, also keep in mind that you're not supposed to count hours, but you still have an obligation to ensure that the employee will have their rest. We also have leave, congé. So the rules are an employee is entitled to basically 5 weeks of holidays. You will have very nice time to explain to a foreign employer what is the difference entre jour ouvrable et jour ouvré, and why they can provide an employee who is 25 or 30 days, depending on if they are jour ouvré ou jour ouvrable. You also will have a very nice moment to explain the fractionnement rules. I will not enter into details, but basically you could have some additional days depending on how your weeks of holidays are structured. And obviously you also have specific days for sometimes seniority or parental obligation or this kind of thing. Remote work, which is obviously something that we all heard a lot with the COVID situation, which is really more and more a question we have and still today about remote work. So principally because, of course, a lot of companies has put in place some, I would say, emergency measure during the COVID. They start to implement some rules, sometimes, you know, without any framework, I would say legal framework. And also, so now we are really in a period of time where companies are thinking of the remote work as a tool also for attractivity. We all heard about the grande démission or the difficulty we have on our client to find people. So it's not only about money, it's also how the working time is structured. So here you have to think how to formalize. So normally it's either in a company-wide agreement or a policy, and you will have a specific clauses in the employment contract that would mainly provide with the expense that you will, so they will have some drafting, but mainly the discussion that you will have with your client is what you have to pay. So in principle, when the company, so for example, here for bicycles, they just have one employee and it's a salesperson. So usually they will not have a proper office, and the employee will work from home. In this case, where the company is not providing for an office, the company has to pay a specific indemnity d'occupation, which is the amount is not provided by the law, and it is quite unusual that a CBA provide for an amount. The reason is really depend on the place that the employee will use or need. I would say that the trend is usually we recommend our client to provide for 100 euro per month. And then is a question of the professional expense, which is in addition to the indemnity for remote work, which is really related to is the using of the Wi-Fi, the using of the electricity, the phone. Generally, we will also provide for a lump sum remuneration, considering that the staff provide for a certain amount that would be exempt from social contribution, which, if I'm not mistaken, is 50 euros if you're in full remote work per month. A question that we have to treat a lot last time is about the travel expense. As you probably know, you have an obligation to reimburse 50% of any abonnement. Travel card. Travel card, thank you. So, and we have clients where we have people that were working in Paris and they have to work from Bordeaux or Toulouse. So the question would be, should I reimburse 50% of the train tickets where I have an employee that I did not really ask to go there? Honestly, my recommendation to the client was, and still is, that if it's a request of the employee, there's no reason why you will pay for that. But it's not the point of view of the judge. So we have not yet a decision from the Supreme Court, but we have a decision that considers that even if it is a decision of the employee, you still have to pay. So you should also have this in mind. And it's really, we have a client with different situations. So we have a client that starts to accept one employee living in Bordeaux, but as it was at her request, they do not change the remuneration, but they refuse to pay for the travel expense. But now they are also recruiting people directly outside Paris. So they decide not to pay them the same salary, but they would compensate for the travel expense. So they are different employees with different treatment.
Nice matter. Few litigation. And actually recently we also had a case, I think, where the employer dismissed the employee because he decided to move far from his job. Yeah. And he had to travel like 200 or 300 kilometers every day by car. And so the employer said, no, it's not reasonable because you could have an accident and so on. And the Court of Appeal considered that they were right to end the employment contract because also as an employer, you have a duty of care to ensure the security of your employees. So you see, it's really the future litigation. A big part of the future litigation will have, it's all about professional expenses, refusing remote work and so on.
So termination, which is also when they will hire, most of the time the client will ask first for the termination cost before even asking you what type of contracts. So I will let Alexandra explain what her is a possibility.
So here we are obviously talking only about really permanent contract because as I explained earlier, for fixed term contract, the termination grounds are quite limited. So the first option is obviously the option where the employee himself decides to resign and leave the company. He would have to follow a notice period, which will depend whether, for example, he's an employee, a supervisor, or a cadre, an executive. And again, you need to check the collective bargaining agreements. And don't forget my little non-compete clause, please. Then you have amicable termination. So it's consent on both parties. It's really a specific procedure. It takes around 5 weeks. You need to meet the employee to agree on the termination indemnity, which is at least equal to the severance indemnity as determined by the law or the collective bargaining agreement, depending on the more favorable. You sign the form. Then both parties have around 2 weeks to change their minds. Then you send the form to the administration. Now, all must be done electronically on a specific website called TeleRC. And then the administration has 2 weeks to approve or refuse. If you comply with the procedure, if you pay the minimum, I mean, it will not be an issue. You will have your approval, and silence after those 2 weeks is equivalent to approval. The interesting thing with amicable termination is that the employee is entitled to unemployment benefits, which is why now we have quite some difficulty in France because a lot of employees don't want to resign because it's a risk taking a new job and so on. Because even if in your new job, your notice period is ended, it's not necessarily that you will have unemployment benefits because the rules are quite technical. So it's a risk sometimes resigning and starting a new job. So it's why everybody wants, amicable termination. So some companies are more or less flexible because, of course, as soon as you start to accept for one, then everybody will want it. And it costs some money because you need at least to pay the severance indemnity. Then there is dismissal. So it's when obviously the employer decides to end the employment contract. So either it can be for personal grounds, for example, poor performance or misconduct. Or it can be for an economic ground. And here the regulation, will not detail it, is quite technical in France. There's specific procedure to comply with, depending on how many people are going to be made redundant, depending on the workforce of the company and so on. And if we just talk about personal ground, of course, you need to be careful that for any kind of dismissal, you need a real and serious cause of dismissal. So in case of litigation, you will need to bring evidence that you have justification for your dismissal ground. So in case of poor performance, it is really important to have emails, appraisal, and so on, which prove the poor performance, because usually what happens is that managers don't like to criticize people below them. And then they come and see us, no, he's really bad. He doesn't do the job. I want to dismiss him. And then you look at the appraisal and the guy is just great. So then, of course, we can dismiss, but then we'll negotiate probably a settlement agreement later. And also about dismissal in relation with misconduct, you need to be really careful about statute of limitation, because the employer needs to act in a 2-month period following the discovery of the facts. So it's important not to wait too much, because otherwise, again, your dismissal will not be valid.
And the final situation is constructive dismissal. There are in here two options. Either it's the employee who send you a letter saying, I end my contract because you did this and this wrong. You didn't pay me overtime. You didn't pay me my travel expenses, my bonus, and so on. And then he decides to sue you and ask that to be reclassified as unfair dismissal and ask for a notice period, severance, and damages. Okay. Or another option is that he stays in his job. Usually he goes on sick leave for months and months, and he goes to court and asks a judicial constructive dismissal called résiliation judiciaire. So then you need to wait for the decision of the judge. So usually sometime you in between manage to negotiate something, amicable termination or dismissal and a settlement agreement. What you need to know is that in France now we have for a few years a scale for the amount of damages an employee can obtain in court for unfair dismissal. So it depends on the workforce of the company, but it's often at least 3 months, depends also on the length of service. And then the maximum amount depends also on the length of service. So it can be up, I think, to up to 20, 22 months, but when you are really like more than 20 years of a length of service. And we just have a recent decision of the Supreme Judicial Court, the Cour de Cassation, which ruled that this scale is valid because there was a lot of action from trade unions arguing it was not compliant to have this maximum amount. And we are waiting, however, for a few decisions at the more international level to see if at the European and level they consider this scale is valid regarding, you know, all the international treaties. And last point, and it's a way to do a transition with Myrti, you must also be careful when you have what we call protected employees. So we have various kinds of protected employees, such as pregnant women, young fathers during the 10 weeks after the child is born, people who are ill because of a work-related accident. The rules are really specific here regarding the termination of the contract. And in particular, you can't necessarily dismiss the person right away, or at least you need a really serious ground, such as gross misconduct. And another category of protected people are actually what we really call the protected employees, basically the member of the Works Council, which is now called the Social and Economic Committee. For them, you need, except for resignation or constructive dismissal, obviously you need the permission of the Labor Inspectorate before doing amicable termination or before dismissing those people. So it's a nice transition for me, for Myrti, to explain just a few words about staff representation, because she could go on for hours and hours on that topic.
So the last point that is usually wearing the foreign client or the representative. Here for bicycle, they will not be in the obligation to organize election because you need to have at least 11 employees. And you need to have this 11 employee over 12 consecutive months. So if 1 month during the 12 months period, you are less than 11 employee or 50 employee, then you do not have any obligation to implement that. So basically was what you used to know as comité d'entreprise and délégué du personnel. This law has 4 years now. Reason why this years we start to do again the election, because most of the first comité économique et social was implemented 4 years ago. You should warn your client that even if you're a foreign company, you still have the obligation to implement SEC. The main difference between the attribution of what you used to know as comité d'entreprise et délégué du personnel, so a company with more than 11 employees but less than 50 and 50 employees or more. So the roles did not really change with the law. So in a company with less than 50 employees, the roles are equivalent of what was the duties and power of the délégué du personnel. So they can raise an individual and collective claim. They are here to promote health, safety, working conditions. They refer complaints to the labor inspector, but there are very limited situation where the consultation is required. So in the mind of your client, the main difference will be there, because in company of 50 employees or more, you will have a lot of obligation as an employer. You have an obligation to consult them on annual topics, which are financial and economic situation, strategy of the company, and the social policy of the company. So those are the three mandatory annual consultation. And then you have to consult on a lot of different topics that have, so obviously redundancy, but basically any projects that would have an impact on the day-to-day management. And now you should also have in mind that now you have obligation also. So basically first it was, I would say, economic situation. Then we have an increase of consultation about health and safety matters. It was raised after the case that was for FNAC. Now we have also an obligation to consult on any project that would have an impact on the environment. This is the main topics the Works Council will be consult about. And I think that's it. I raise the point of the environmental consultation, so I take also this opportunity, even if it's not part of our usual coffee morning, to also raise your attention about the lanceur d'alerte, which is a new protection that are entering into force at the beginning of the month. So you have to modify the internal rules, and you have to put, depending on the size of the company, to put in place a specific procedure in this case. What are new things? The prime de partage de valeur, which is also something that we have a lot of questions from our clients. And you will also have an obligation mid of October about information to provide about something that we do not discuss is épargne salariale, so any scheme of participation intéressement. That are the last, I would say, news. And I think that we have covered the usual concern that would have during your first conversation a foreign client.
So Myrthe and Alexandra, thank you very much. I think you've been quite exhaustive.
And we're
on
time.
Is there any question from the floor? I have one.
You are allowed?
I don't know. We'll see. Yes, I have one, because now you have got mobility, a lot of things about moto, bicycle, and it's all about coming to the office or going. So how it works now with the social law?
Well, there has been quite a change, because now the provision are quite technical, because you have now rules on the transport card. If you take the tube, you have rules for the bicycle, you have rules if you take your car, and so on. And so basically the employee needs to define the rules in his company. Some of the options are actually options, like the level of coverage and so on. And actually one of the laws that was implemented middle August changed a little bit the rules and the threshold of the amount you can reimburse to the employees without having to pay social contributions. But to be honest, it's really quite a technical area, because each type of mean of transport, has its own rules and also its own amount up to which there will be no social contribution. But it's true that it's a new topic. And now that we are talking about environment and so on, it's really important for companies and HR to show that they are reimbursing the electric bike and so on. I mean, it's something that is useful for the company.
Do you think that companies will have to provide parking or something with the moto movies in Paris paying?
it's not something that for the moment we have questions about or
yeah, no, and I mean you're really
and it's very Parisian.
It is.
No, but
so and I mean your obligation, strictly speaking, is only paying 50% of the transport card. So then it's a personal choice to take your car, but you could take like everybody the tube. So I would answer that if you ask about.
No, just ask question because that's something I'm sure that it's going to
come, or the cost about it.
Exactly, the cost and everything.
Yeah,
and it can also be something to attract talents, you know. So
yeah,
that's what
absolutely.
I'm thinking about that.
Yeah.
So this was my question.
Question maybe about the meal vouchers, the ticket restaurant. It's a very common benefit in France, and we have a lot of questions from our clients for this. Mandatory, not mandatory. It's not mandatory, but it's so common now that it's almost mandatory. So what can an employer do? Reply? What's your recommendation?
Well, but no, I mean it's not mandatory if you provide a place for the person to have lunch and so on, or you have a restaurant, and rules a bit depend also on the workforce of the company. But as you say, it's really, I mean, everybody expects to have this little ticket restaurant. Now it's a kind of credit card for the ticket restaurant. So then, they compare with the other company, they don't offer me that or that. It's a bit the same if you don't have the forfait jour and the rest days, they just want the same thing. So it's something which is quite common up to a certain threshold. The employer's contribution, it's exempted from social contribution. It has just been increased recently, I think only for a limited period. I don't remember, sorry, the exact amount. But again, as a measure to increase the money employees have, in this period of crisis and so on.
That they can spend.
Yeah, and now they can spend also, before you couldn't buy sugar, for example, because you need to transform sugar or flour, but now they can buy flour. But I think it's only until the end of the year, if I remember correctly. So the rules are also changing, but it's part of this law of August, which has implemented various measures to increase the, I don't know what you say that in English, the pouvoir d'achat of the employee, so the capacity to buy and so on. And this is one of the measures that they're trying to use. So yes, it's quite common to offer that, even though it's not always mandatory.
Yeah, but I think it's part of the
package.
Attractiveness
Exactly.
of new talents. If the large companies do that,
they will expect.
They will expect to do it.
And it's interesting because part of it, you don't pay social contributions on it. So if you increase the salary, you would pay social contributions on it. So it's also useful for the employer in a way.
Other questions from the screen?
We don't have any question in the chat.
No. There was one from Fiona, but it will be seen at the next time.
Okay, great.
So if there is no more questions, so I will end this session. And thanks Myrtine and Alexandra for their bright presentation, clear, quite exhausted. You can say all, but I think we had most of it anyway.
You say exhausted, not exhausting, I hope.
Yeah. Yes, exactly. That's what I said. No, I don't think it's exhausting. It's still morning, And thank you, Valentine, for organizing it. Thank you to everybody.
Thank you.
Thank you.